Hello, I'm David Mandell, one of the principals of OJM Group. And in this month's webinar, we're going to be drilling down into a topic underneath the general heading of asset protection. And we're talking about limited liability companies and family limited partnerships, LLCs and FLPs. And our topic today is, are these three weaknesses lurking in your LLC or FLP? Now, before we get started, of course, we need to advise you that what I'm going through today is not intended to be, nor is it legal advice. Certainly, at OJM Group, we consult on some of these topics, and I maintain my law practice separately out in California. And we encourage you, if this topic is of interest, is to chat with us to see how we might be able to help you in either forum. But OJM Group is not engaged in the practice of law, does not provide legal advice. Always consult with an attorney regarding your specific legal situation. So, we also have our materials, our books, and for anybody watching this live or in recorded form, anybody who watches our OJM Group webinars is welcome to get one or more of our books for free. And you can see we have certainly plenty of books for physicians, which make up a large group of our clientele. We have some books here for entrepreneurs and business owners, including the one on the bottom right, Fortune Building for business owners and entrepreneurs, which make up a fair amount of our clients. And we encourage you to get any of these books. We have them in hard copy, Kindle, and iPad form. And as we get to the end of this WebEx, I will explain to you how you can get them. So what are limited liability companies, LLCs, and family limited partnerships, FLPs, and why use them? Well, technically, LLCs and limited partnerships are legal entities that you can set up in any of the 50 states. Now, you see the word family in front of family limited partnerships. It doesn't mean anything other than typically it's been used in a family context. In other words, there's no such thing legally as a difference between a family limited partnership and a limited partnership. And you could put the word family in front of limited liability company. But the vernacular has seemed to have arisen that people understand FLP and family limited partnership, whereas they don't put that word in front of limited liability companies in general. But technically, an LLC is a legal entity you can form in any of the states, and a limited partnership is an entity you can form in any of the states. Now, why would clients, business owners, entrepreneurs, physicians, families set up limited liability companies or limited partnerships? Well, there are a lot of reasons. In a business context, you might use an LLC because you want to limit your liability protection. You might want to take on investors, etc. And that's a whole other area of discussion that we could have. But today we're really focusing on family planning. And for LLCs and limited partnerships, people use it for family wealth planning. Why? Because if you want to consolidate sort of control or management of family assets, these would be the tools to use. If you want to get family members involved with understanding investments and wealth planning without having to give them real control of assets, you would use an LLC or family limited partnership. If you wanted to do some gift planning, so make gifts to family members, kids, grandkids, etc., but you didn't want them to be able to access or control the assets that you wanted to give, you could give them limited partnerships or membership interests in an LLC or limited partnership, give them an understanding, give them something of value, get it out of your state for estate planning purposes, but yet you don't give them anything that they can go squander. In fact, another bullet point I could have added here is estate planning, and really gift and estate planning go together because assets even left inside of limited partnerships and the LLCs can, if done properly, qualify for discounting, not only from the gifts, but actually the asset, even if you pass away with those in your state, the IRS has recognized certain discounts, so the value of an asset inside an LLC or a limited partnership can be worth less than the same exact asset outside of it for estate tax planning purposes. I'm happy to chat with you more about that. But what I'm focusing on today is really asset protection. Okay, so we could have a whole nother WebEx just on using LLCs and limited partnerships for gift or estate planning or family wealth planning. But today we're going to talk about it from a context of asset protection. Why do clients use LLCs and limited partnerships for asset protection? Well, you have to understand the difference between inside and outside protection. Inside protection is the concern that because of a business or because of an asset, there may be liability, and I want to isolate that liability just for that asset, not have it potentially infect any of my other assets on my balance sheet. And for that reason, LLCs are extremely important and are the standard operating entity for real estate, for example, across the country. If you do have real estate and you don't own an LLC, there should be a real good reason why not, because real estate generally is dangerous, whether it be rental property or commercial property or land. And the way to isolate that potential liability away from other pieces of property and away from other assets is to have it in a properly designed and maintained LLC. So, for example, I have a client who has 28 pieces of real estate, 28 LLCs, each one separating it from the other, as well as their other family assets. Okay, that's inside protection. And in that context, LLCs are much better than family limited partnerships or LPs because the general partner of an LP has liability, whereas a manager or a managing member of an LLC does not. Okay, so LLCs are preferred for dangerous assets like businesses and real estate. Now, outside protection is different. It's not the risk that the asset will create, it's risk to the owners of that entity. For example, let's use a physician as an example. A physician gets sued for malpractice and they own a portfolio of $1 million. They could lose half of that or maybe all of that to that lawsuit, even though that risk had nothing to do with the $1 million sitting in the bank. That $1 million in the bank did not create the liability. It's outside liability. It's the liability that that physician may incur from a car accident or a malpractice action or an employee claim. And in that sense, it's extremely important to protect safe assets like investments or securities or cash, etc. And that's why limited partnerships, FLPs and LLCs, are often used by business owners or physicians to protect personally owned or family owned safe assets from claims related to their business or other activities. And in that context, as a lawyer, I've set up for the last 20 years hundreds and hundreds, probably closer to 1,000 entities. And under the OJM umbrella, as a consultant, I've looked at the work of another 200 lawyers, law firms across the country. And I think that experience doing it myself, being on communities and listservs with other attorneys to do it, but also from my role at OJM Group as a consultant looking at the work of hundreds of other lawyers, I've seen in my clientele best practices. I've learned a lot from others, but I also see very commonly a number of different weaknesses, and that's what we're going to talk about now. So weakness number one, we'll get to in a second. Before I do that, I want to put this in perspective, and if you have any of our books, which I encourage you to, if you've seen other of our webinars, you understand that we look at asset protection at OJM Group as a sliding scale. So it's not, am I protected or not? Does this entity, LLC, protect me or not? It's to what degree does it protect the asset? To what degree does it put me in a position to negotiate a settlement or discourage a lawsuit? To what extent does it leave me vulnerable? And I've been using in the books for 15 years now a -5 to +5 scale, -5 being an asset that's totally exposed. There's no protection. There's no discouragement. There's no settling. Total exposure, and +5 being an asset that's off the table. No settling, no position of strength. The asset is clearly exempt from those creditors' lawsuits against you. And while we would love to get our clients to the +5 position throughout their balance sheet, that's not realistic. So our process in our consulting is to work with them to move as much of their net worth from the negative positions to the positive, and especially take advantage of whatever +5 they can, but use tools like limited partnerships and LLCs and certain types of trusts to bridge the gap between negative total exposure and +5 total protection. And that's where most clients have a lot of their net worth. They can't get the +5 across the board, so they're looking at using trusts, limited partnerships, LLCs, certain types of ownership in certain states to bridge the gap and give them a solid level of protection so they can sleep at night and not have a lot of their assets totally exposed. So when we talk about LLCs and limited partnerships over the next couple of minutes, you've got to put in perspective that even if they're as good as they can be, they're in the middle of the scale, solid, but they're never going to be +5. LLCs and limited partnerships are +2. They put you in a position to negotiate with a creditor. In that worst case scenario, they put you in control. They may discourage a lawsuit or someone coming after those assets, and it may encourage a favorable settlement. Those are all wins in the asset protection world as compared to negative positions where you have no position of strength. So given all of that, when I see clients who brought me LLCs and limited partnerships they set up, what do I see as the top 3 weaknesses? Well, weakness number 1 is probably pretty intuitive for clients, and that is just not following the annual formalities. If you've set up an LLC and a limited partnership a number of years ago, and you haven't had any annual meetings, you haven't done any updates to it, you haven't had an attorney sort of oversee on an annual basis, then your LLC or limited partnership is not maximized, and it may be extremely vulnerable because of that. It's got to be in compliance with tax law. It's got to be in compliance with the legal filings. It should have another level of formality, including member meetings, reporting from non-managing members or members where there's a manager for the LLC. There should be updates to the operating or partnership agreements if the law warrants it. There should be an annual file and an annual upkeep, and that's what I do from my law firm side for clients who have entities that I've created with them or I've taken over the compliance. We have an annual program where we make sure that these things are getting done so that the entity is complied with all its formalities. And that's pretty intuitive. You set something up, you never pay attention to it, you don't update it, you don't do what you're supposed to do, you're not going to get the benefit of that medicine. If you go to a doctor, they're going to say, I need an annual checkup. It's the exact same thing for your FLP or LLC. You need that annual checkup. Pretty obvious on that, but again, I see many clients who've come to me and say, yeah, I set this up, I haven't done much with it, I haven't looked at it in a long time, tell me what I need to do. Pretty common. The second weakness is a little more technical, and it's something I wouldn't expect, the typical business owner, entrepreneur, physician, family member to be aware of, because you're not attorneys practicing in the field. But the bottom line is, I'll use an analogy like a will. Anybody can have a will. But what your will says versus what my will says versus what my partner's will says can be very different compared on what we actually put in the will. And when it comes to asset protection, which might be the inside protection, might be the outside protection, the LP or the LLC is only going to be as good in that protective capacity as what's written in there. So if you have, and as I've seen before with clients, language in those agreements that open the door to outside creditors, they can walk right in. There's no protection whatsoever from that entity from an outside perspective, because that's what the LP says. I don't care that it's an LP. If it says that in the agreement, that's what it is. And a judge making a ruling on whether those assets were vulnerable or not, going to follow that agreement. So an LLC or limited partnership, like a will, is only protective as its agreement. And the good news about me looking at the work of 200 law firms across the country, in addition to doing this for 20 years, is I think I have a pretty good handle on best practices. Just like in your business, if you saw other competitors or folks in your business do what they do in an intimate way 200 times, you probably learn a couple things. Certainly the physicians on the phone, same thing. You see somebody who does a surgical procedure that you do every day, and you watch 200 good practitioners do it, you're going to pick up the best practices. But if you also see 200 people do it, you probably see a lot of them who aren't doing it at best practices because they haven't had the benefit of seeing everybody do it as you have. That's what I see. I see over and over on a weekly basis clients come to me where they've set up entities that do not have the best practices of asset protection. Technically, I could say it doesn't have the right language on rights of involuntary transferees. It doesn't mirror the charging order rules in their state. It doesn't have a distinguishment between pro rata, or the ability for the controlling people to make pro rata or non-pro rata distributions. It doesn't get into the poison pill of K1 issues when there's the charging order filed. It doesn't get into fraudulent transfer language. A lot of other things that I'm looking for in my checklist. Most agreements don't have it. Now the good news is, if you've set up one of these and you don't have that language, it's very easy to amend an LLP, an LP, or an LLC. Even easier than to amend a will, because you don't need witnesses, you don't have to make any filings, you just restate it, or you do a couple-page amendment to improve it. Very easy to fix, but very common problem. So I encourage any of you who have LLCs and limited partnerships in place that we chat and see if I can review it and see if there's a way to improve that language. Then the third weakness is not as common but still out there, which is not choosing the right jurisdiction for the entity based on what you're using the entity for. There are articles, there are annual reports that colleagues of mine, friends of mine do for lawyers across the country, where every year they look at how the law has changed and they rank limited partnerships in LLC jurisdictions and often just different types of trust jurisdictions based on the state of the law and where, if a client has a choice, where they should be setting these up. Now, sometimes you don't have a choice. If you're operating a business in Florida where I live, then you got to use an entity in Florida because you have to do business here. Same thing if I have a client in California and they have a piece of real estate in California, we got to use a California LLC to own that piece of property. But if I have a client in Illinois and they use an investment firm that's based in Ohio, but they custodian those assets with one of the large public companies like TD or Schwab, and that public company has a headquarters in California or New York, but they are a Delaware corporation as a multinational. Where are those assets when you check the balance online? Are they in the client state? Are they in the state where the investment firm is? Are they in the state where the custodian is headquartered? Are they in the state where the custodian is legally domiciled? So the point is that for those kinds of assets, investments, cash, securities, other personal property, you may be able to use jurisdiction of your choice. And if you do, then let's drill down and figure out which jurisdiction is most protective, maybe which one has the best discounting, maybe which one has the lowest fees, how many owners you're going to have, lots of different factors for us to choose what is the best jurisdiction, or at least one of the top ones to use rather than one of the bottom ones. And again, sometimes I see clients who haven't thought that through. So today I drilled down very quickly into one subset of one area that at OJM we consult on. We consult on asset protection. Now, if there's legal work that needs to be done, maybe my law firm or another law firm, one of your lawyers can do that. That's implementation of legal tools. We don't do that. We're not a law firm. But the consulting side, telling people what exists out there, educating them on their options, that's something we do. And in asset protection, LLCs and limited partnership, just two of the tools, including property and casualty insurance and benefit plans and captives and debt shields, that a client can put in place to put some protection around different business or personal assets. That's just one area, asset protection. And as you know, if you're a client or you've been reading our materials, there's lots of other areas we work with clients on, and we don't have to do everything. We can just do one or two, whatever makes sense for the client that they want to use to make their life easier, to save money, to save time, etc. So whether that's tax or business, corporate structure, or benefit planning, or retirement planning, or college education funding, or a whole different level of insurances, or wealth management, we have experts and we're interested in speaking with you about that. About us, if you don't know, we're a pretty unique wealth management firm. We have 1,000 clients throughout the country. Most are physicians or business owners, entrepreneurs. We're multidisciplinary. As you could see from that chart before, we have a lot of different areas where we have expertise. We have a consulting division. We have an insurance and benefits division. We have a wealth management division. We have something that's called our firm commitment. So if we're helping clients reduce taxes at a business or a practice, we can't save them 200% of their fee in terms of tax savings or other savings. We'll refund the fee, and that's for qualified clients. So, you know, there are a lot of areas and elements of our firm that I think are pretty unique in how we help clients on a day-to-day basis. So, as we conclude, I would encourage all of you to come to our website, ojmgroup.com, or contact me at mandell@ojmgroup.com, or give us a call at the toll-free number on the screen. And we will be happy to have a free consult with you and chat with you about asset protection or any other area. I would also encourage you all to get free copies of our book, any of our books, whether that's a book for physicians, a book for business owners, the fortune building for business owners and entrepreneurs, or our book for doctors only. And in this case, you can do that by coming to our bookstore, which you can see on the screen, ojmbookstore.com, and use our promo code WEB1115. So WEB1115, which would obviously correlate to November 15 when you're watching this webinar. So WEB1115. Feel free to contact me at my email, mandell@ojmgroup.com, at our phone number. Get a free copy of For Doctors Only, get a free copy of Fortune Building for Business Owners and Entrepreneurs, any of our other books, or contact us to have a free consult. We'd love to chat with you about this or any other topics that we can help clients with. Thank you for your time.